This is David Demergen for Tactics and Trials with a legal update for March 2023. Every 2 weeks, I'll be coming out with an update regarding case law and cases that are important for the law enforcement industry. As some of you already know, I've been a practicing attorney for 30 years in several states around the country, most recently here in California. During that time, I've represented some of the largest police agencies, both in federal, state court, criminal, and civil matters. So I'm able to look at some of these cases a little bit different and give you a heads up regarding some of the issues that the court is raising for you. In the case that we're going to look at, there are a number of technical issues that I hope you'll bear with me as I try to clear up the confusion, because it is a confusing case, but hopefully by the end of this update, you'll have a better grasp of the facts and the law and the legal holding of the court. Now, just so we get off to the right start, we're going to be looking in federal court this time versus a state court matter. Federal court, has its own jurisdiction. State court has their own matters. All right. And in this matter, we're going to the Federal Court of Appeals in the Ninth Circuit. There are 13 federal circuits in the United States. The ninth, which is mostly the western states, is the largest circuit in the country. In the Ninth Circuit, we have California, Washington, Oregon, Arizona, Idaho, Montana, Hawaii, Nevada, Guam, Alaska. A very busy circuit and generates a lot of opinions. The case that we're going to look at today is Duarte versus the city of Stockton. The opinion came out February 26, 2023. Now, I'm going to read you the holding, and it goes on for a couple of paragraphs, but bear with me with some of the technical items. I'll hopefully be able to explain those as I get to those points. In this matter, the Ninth Circuit Court of Appeals held that the U.S. Supreme Court decision of Heck versus Humphrey does not preclude a 42 U.S.C. Section 1983 claim by a plaintiff who pled no contest to, but was not ultimately convicted of a crime. Heck held that a 1983 action does not permit claims that would necessarily require a plaintiff to prove the unlawfulness of a conviction. In Duarte, the plaintiff pled no contest but completed the conditions of a pre-trial agreement, entry of plea held in abeyance, and the charges were dismissed before the court could enter an order finding him guilty of the charges to which he pled. The Ninth says Heck requires an actual judgment of conviction. As the court stated specifically, we have never considered whether the Heck bar applies when criminal charges were dismissed after entry of a plea that was held in abeyance pending the defendant's compliance with certain conditions. We hold Heck does not apply in this situation. I know it's confusing, but let's start at the beginning. First of all, what was the case, or what is the crime that Duarte was charged with in this matter? In the state of California, he was charged with a violation of Section 148 of the Penal Code. Now, 148 is our resisting arrest section pertaining to all violations along those lines. Specifically, Penal Code 148A describes resisting arrest as any criminal conduct that resists, delays, or obstructs any peace officer in the course of their official duties. Penal Code 148 PC makes it a crime to willfully resist a police officer while performing their duties. Duarte was arrested for a violation of 148. Now, just understand, resisting arrest, impeding, hindering an officer in the scope of their duties in other states has a different section. So be aware of that. And as I reminded you in the beginning, please check with competent counsel of your jurisdiction, because this can be very technical. Now, if you notice in Duarte, they make reference of a 42 U.S.C. 1983 action. What's that? 42 United States Code, Section 1983. That is basically the civil action for deprivation of an individual's rights. Most of the time you see these 1983 actions, first of all, they're only in federal court, and that can be in any of the circuits. 1983 action is usually for excessive force by a police officer or deputy sheriff or law enforcement personnel. However, the 1983 action can be used against any government official who deprives an individual of their constitutional rights. School officials, school district officials have had 1983 actions. All different types of government officials. But in this case, we're talking again back to excessive force. But it's a civil action by the plaintiff suing the officers for excessive force. So as you see, we have two matters going. We have a 148 resisting arrest, which Mr. Duarte is accused of, And we also have him commencing a civil action against the police officers for excessive force during the incident that led to his arrest in the 148. You see the connection at least. And that's what we're going to be talking about here, because this is what Duarte discusses. Now, in the civil action that he's commenced, there's mention of Heck versus Humphreys. What is that? Heck versus Humphreys is a U.S. Supreme Court case in 1994. Heck versus Humphreys makes the connection between the 1983 civil action and the criminal charges, in this case, the 148 violation. That case, written by Justice Scalia, who unfortunately is no longer with us, wrote, "We hold that in order to recover damages for allegedly unconstitutional conviction or imprisonment, or for harm caused by action whose unlawfulness would render a conviction or sentence invalid, a 1983 plaintiff, Duarte in this case, must prove that the conviction or sentence has been reversed on direct appeal, expunged by executive order, declared invalid by a state tribunal authorized to make such a determination, or called into question by a federal court's issuance of a writ of habeas corpus. A claim for damages bearing that relationship to a conviction or sentence that has not been so invalidated is not cognizable under a 1983 action." So that's what they call the Heck bar. Basically, you can't be incongruous between the two. You have a civil action alleging excessive force by the officers, but in the same light, we have a criminal action started by the state, or the people of the state of California, alleging that the defendant wasn't complying and force was appropriate in that instance. Scalia is saying, in his opinion, under Heck, there's only certain ways to challenge the conviction in the criminal court. And the only way you can do it is by the way he lists, not by the way that was attempted by the city in this case. But let's get into the details of what we're going to talk about here, the fact pattern. Now, just so you understand, this was on a motion for summary judgment. I will not go into the details of what a motion for summary judgment are, but basically it's the city and the officer's way of trying to get out of the civil litigation before going to trial. Trials are expensive, very expensive, and prolonged. So a way of trying to avoid that after going through some level of discovery is to file a motion for summary judgment saying, hey, based on the facts alleged, based on the law as it stood at the time, there is no case here. And that is what's being appealed up to the Court of Appeals, because the federal district court judge agreed with the city, agreed with the officers that the case was not viable and should not proceed. Mr. Duarte took it up to the 9th. Now, let's get into what the facts were. On May 5th, 2017, Duarte was in a public area in downtown Stockton protesting with other individuals. Several of the officers had an individual detained who was protesting, I guess, beyond the scope of normal protest, whatever you want to define that as. That's not the issue here. And the officers ordered Mr. Duarte back away from the group as they detained this individual and possibly took him into custody. According to the officers, Duarte did not listen. According to Duarte, he said he didn't hear the order. It was not trying not to be compliant. At one point, he gets too close. One of the officers then, or several of the officers, take Mr. Duarte to the ground. They order him to provide his hands. According to him, he wasn't able to because the officers being on his back. They're saying he was just resisting arrest. At that point, one of the officers takes his baton and strikes him in the leg, thus resulting in a broken bone to Mr. Duarte. Mr. Duarte at that point, or during this incident, then puts his hands behind his back, is placed in custody, and placed under arrest for Section 148 violation, resisting arrest. He is then taken to the hospital, taken to custody, and proceeds according to the criminal court. Now, on July 12, 2018, Duarte and his attorney, represented by counsel, both signed a document titled Misdemeanor Advisement of Rights, Waiver, and Plea Form. In this advisement of rights and his waiver of plea form, which is basically saying, look, I'll agree to this, let's get this matter resolved now. I don't want to go any further in the criminal matter. He says, I understand that a plea of no contest will have exactly the same effect in this case as a plea of guilty, but it cannot be used against me in a civil lawsuit. My decision to enter the plea has been made freely and voluntarily. No promises or inducements have been made in connection with this plea except plea in abeyance. That's what we have, is a plea in abeyance. And in order to complete this plea in abeyance, he needs to do 10 hours of community service at any nonprofit of his choice. 6 months, he basically has to comply with the law. In that time period, he does complete the 10 hours community service. He then is obeying of all the rules, regulations, and laws of the state of California. the plea is vacated and dismissed on January 12, 2019. If he fails to do so, then he'll have a guilty verdict on his record. He'll also have 3 years of informal probation. That's if he didn't comply with the terms and conditions. But he does, and he complies with the terms and conditions. What happens is the court doesn't order the conviction. It's held in abeyance while he complies with the agreement that he struck with the district attorney's office. So since that is held in abeyance, the condition of the agreement, as I say to, is the 10 hours of community service and obey all the laws. 6 months later, it gets dismissed upon the motion of the deputy district attorney in the interest of justice by December 31st, 2018. At that point, remember, Duarte at this point, the case is dismissed. There is nothing on his record because there was never an order of conviction. Well, December 31st, 2018, Mr. Duarte retains counsels and sues under a 1983 action, the civil action, against the officers in the city of Stockton. When they go to court, in civil court, eventually counsel representing the city and the officer says, hey, Heck versus Humphrey bar. He already admitted over in criminal court what he did wrong, and under Heck versus Humphreys, remember what Scalia said, this is not the way to attack that conviction. Well, according to the Ninth Circuit Court of Appeals, this is what's interesting. It's the first time they've ever dealt with a plea held in abeyance. The absence of a criminal judgment renders the Heck bar inapplicable. The plain language of the decision requires the existence of a conviction in order for a 1983 suit to be barred. To be sure, Duarte pled no contest to the resisting arrest charge, and under California law, a court ordinarily shall find the defendant guilty upon entry of such a plea, which is considered the same as a plea of guilty. California Penal Code Section 101, 1016, subsection 3. But the only serves to underscore that a plea itself is not a conviction. That's the point. He has a plea. It's held in abeyance. There's no order of the court of a judgment of conviction in here. There's no judgment of guilty. There's no judgment of ordering the conviction. There's no recognition of the fact that they were in this agreement. What's missing, according to the court, stated, legal challenges that cast doubt on such a criminal judgment, which would have been his resisting arrest, which is not a criminal judgment since we didn't have a judgment, are the province of a direct appeal or habeas corpus, not a 1983 action. But whereas here, the criminal charges were dismissed and there is no conviction to impugn the tension with which Heck was principally concerned is missing. Also absent are such concerns about finality, consistency, or comity when there is no order in the state criminal case with which a decision in the federal civil lawsuit could be inconsistent. That's the point of Heck. But we don't have that because we have a plea held in abeyance. And the court's saying, hey, doesn't impact its ability to go forward in the 1983 action. Thus, motion for summary judgment, reverse, remanded, sent back to court. Those officers in the city now are going to have to sit through litigation, probably go through trial if they don't settle it up in mediation or arbitration, and eventually prove whoever's right at the scene. If it's excessive force, necessary force, was it appropriate under the terms and conditions of whatever happened? I don't know what the situation was up there. But as for what we found out here, when they entered the plea on the 148 here in the state of California, it's very important as to how that plea or how that matter is handled. It just can't close your eyes and say it's go away. Now, just a side note, the Ninth Circuit is in agreement with some of the other circuits, but not in full agreement with other circuits. We have a split in the circuits. Some circuits would have accepted that type of plea, this plea in abeyance. Others would agree with the Ninth on this. When you see the circuit split like this, there's usually a matter or an issue that is ripe for the Supreme Court to then issue a decision regarding how it's going to be held from this point on. This is David Demergent for Legal Update. If you like what you see, please hit the like and subscribe. We're hoping to get out something to you every 2 weeks regarding important cases, decisions, or matters that impact the law enforcement industry. I hope you enjoyed this time. I look forward to seeing you again.